Welcome back to Criminology 4385, Civil Liability and Criminal Justice. Once again, as I will do at the beginning of each one of these modules, I want you to take a look at your updated syllabus. We are in Module 2 now. The dates are March 31st and April 2nd. And in this module, we will be talking in some detail about the Section 1983 lawsuits. Again, these lawsuits are discussed in some detail in Chapter 4 of your text, and I encourage you to read that chapter, but I'm not requiring you to read it. You will be in good shape if you listen carefully to this lecture and take good notes with respect to this lecture. I'm going to proceed as carefully and deliberately as I possibly can, because I know this is new information. This is a new territory for most of you. Okay, and in addressing this module and dealing with this lawsuit, you will need two items. You will need the discussion outline for this module. You have a discussion outline at the top. It's written in handwriting, Chapter 4, Section 1983 lawsuits. There's an outline there. It goes from Roman numeral 1 down through Roman numeral 8. And I'm going to be going right down this discussion outline in this module. You'll also need a handout. Again, at the top, it's entitled Chapter 4, Section 1983 lawsuits. And then it says mechanics of a Section 1983 lawsuit. We're going to go step by step through what happens when one of these things is filed. Okay, so you need those two pieces of paper. Looking at the discussion outline, I'm going to make some general comments. Roman numeral 1, Roman numeral 2, I'm going to talk a little bit about the history of Section 1983. Not a lot of detail. I'm not going to spend a lot of time on that, but I'll make a few comments. Roman numeral number 3, those are the 4 essential elements of an 83 lawsuit. Those 4 things have to be present. Roman numeral 4, we talked about this already. We've kicked that can down the road about as far as we can, but the remedies under Section 1983, the monetary damages and the equitable relief. We talked about that. Number 5, who pays the monetary damages? You know, if the jury should find in favor of Denicia Perry's client and against Deputy Pruitt who didn't double lock the handcuffs, and as a result of that, Denicia Perry's client suffered nerve damage in his wrists. Who pays, and the court awards her client some money? Who pays that money? Not Deputy Pruitt, but who pays the money? Number 5, the provision of legal representation. Who's going to represent Deputy Pruitt? Who represents government defendants, police officers, correctional officers? They need legal representation. Obviously, Denicia Perry's client retained her as his attorney. Number 7, the assessment of attorney's fees. Just a couple of sentences there about attorney's fees. Part of the award a lot of times in these cases is if a plaintiff gets a damage award money, that takes place, but also the attorneys who represented that plaintiff. They're often awarded their fees. So that's part of the award also, but that money goes to the attorney. And then number 8, we're going to walk through the mechanics of one of these lawsuits, okay? So let's get started. I'm going to make some general comments. For the rest of this semester, we're going to be talking about civil lawsuits filed under the authority of 42 U.S.C. 1983. Again, that's Title 42, Section 1983 of the United States Code. USC stands for United States Code. Okay. The courts have ruled in the past that you can't use Section 1983 to file a lawsuit against a federal employee. an FBI agent, a an officer in a federal prison, correctional officer. Those are filed under the authority of Bivens versus 6 unknown agents of the Federal Bureau of Narcotics. That was a 1971 case, and I can't explain why. I'm sure a law school professor could, but it's not that important for this class. Just know that these lawsuits filed against federal agents, federal employees, are called Bivens actions. Bivens, B-I-V-E-N-S, actions. We've covered that already in class. So we're going to be talking about, and when a Bivens action is filed, it's the same content. It might as well be a Section 1983 lawsuit. The same allegations are made, the same relief is requested, but it can't be an 83 lawsuit. It has to be a Bivens action. So I'm going to talk in this module about 1983, Section 1983 lawsuits, but keep in mind that in the minority of cases, in a relatively small number of cases where the defendant is a federal employee, that's a Bivens action. So keep in mind that what I say applies to Bivens actions as well. Okay. So anyway, we're going to be spending the rest of this semester, the rest of these modules, talking about civil lawsuits filed against police officers and officials and correctional officers and officials under the authority of 42 U.S.C. 1983, in which somebody is claiming that an officer or officers, an official or officials violated their rights under the United States Constitution. And they're using 42 U.S.C. 1983. Remember, that's the federal law that gives anybody direct access to the federal courts if they feel that their rights have been violated or are currently being violated. You have that access. I have that access. It's one of the great things about this nation. The federal courts are available to people who feel their rights have been violated. There's really no sense in having a constitution or any regulation unless you can complain or grieve if you feel that you've been wrongfully handled, that a wrong has been committed. We talked about the 6 amendments to the Constitution that are most frequently cited in these lawsuits against police officials and correctional officials. The first 5 of these 6 are part of the Bill of Rights. They're part of the first 10 amendments to the Constitution. They are you know this, we've covered this already. The First Amendment deals with religion, the establishment of a religion, and the free exercise of that religion. In our correctional institutions, the free exercise of a religion is most frequently the subject of these lawsuits. An inmate will claim that he's been restricted as far as freely exercising his religion. That First Amendment also gives us the right to peaceably assemble and express our grievances against the government, so law enforcement gets involved there on the streets. The Fourth Amendment protects us all from unreasonable searches and seizures. In other words, searches and seizures without probable cause. The Fifth Amendment protects us against self-incrimination and basically says that nobody shall be deprived of life, liberty, or property without due process of law. That's the Fifth Amendment. The Sixth Amendment provides us with the right to legal counsel. We have the right to an attorney. In a criminal matter, in these civil matters, in a civil legal proceeding, you do not have the right to an attorney. But a lot of times what happens is somebody will claim in a civil lawsuit that when they were arrested, for example, by the police, they were not told that they have the right to an attorney. Well, you have the right to an attorney if you are being taken into custody in a criminal matter. Then you have the right to an attorney, which means that if you can't afford one, the government has to provide one for you. If that right is violated, it could wind up in a civil lawsuit. So you understand what I'm saying? So if you are filing a civil lawsuit claiming that you weren't given your right to an attorney when you were arrested by the police in a criminal matter, you file a civil lawsuit. You do not have the right to an attorney in filing that civil lawsuit. You have to retain your own. In our hypothetical example, the gentleman whose nerves were damaged by Deputy Pruitt's handcuffing did retain Denise C. Perry. Didn't have the right to an attorney, but retained Attorney Perry. The Eighth Amendment protects us all from cruel and unusual punishment. In your prison, for example, that's a punitive environment. And you have the right, we all have the right to be, imprisonment does involve punishment. That's unavoidable, and it's supposed to. But the punishment cannot be cruel and unusual. Officers can't beat prisoners. They used to. They can't anymore. That is considered cruel and unusual punishment. The Eighth Amendment, we also mentioned in class, also prohibits excessive bail. There's no right to bail, but there's a right to be protected from excessive bail. And then, so those five amendments, the First, Fourth, Fifth, Sixth, and Eighth, are part of the Bill of Rights, and they're the ones that are most frequently cited in these lawsuits. The 14th Amendment, which is not part of the Bill of Rights, basically reminds people that if you are a state or a city, if you are part of the United States, the Constitution applies to you as well. You can't have your own. You can have your own Constitution, and all the states do, including Texas. But it has to be consistent with the United States Constitution. It can provide you with more rights than the U.S. Constitution provides you with, but it cannot provide you with fewer rights. And so most of these lawsuits are filed against counties and cities and the agencies they're in. And so most attorneys will throw in the 14th Amendment in their complaint, reminding people that the U.S. Constitution is in play here, and the 14th Amendment guarantees that. Okay, so anyway, that's how we'll proceed. So that's my general comments about where we are. I want to briefly talk with you about the history of Section 1983. And I'm not going to say that much about it, but I will say this. In 1866, 1 year after the conclusion of the Civil War, Congress passed the very first Civil Rights Act. And it was meant to protect the freed slaves in the South, the freed black slaves in the South. And it was intended to ensure that people understood that they were now citizens of this nation. They were no longer slaves. They were free citizens, and the Constitution and all of its protections applied to them as well. 2 years later, in 1868, in order to, I think, reinforce this idea, the 14th Amendment was passed. And Congress went on record as saying, hey, if you are a state in the former Confederacy, the U.S. Constitution now applies to you. And it was meant to make that very clear to places like Mississippi, Alabama, South Carolina, Texas, members of the states that had been members of the part of the Confederacy. So that was 1868. In 1871, 3 years later, in another attempt to reinforce this principle, Congress passed 42 U.S.C. 1983. So Section 1983 goes back to 1871. And it made the point that if somebody, including a former slave, felt that his rights were being violated or had been violated by a representative of the government, he could file a civil lawsuit in federal court. So that's 1871 is when Section 1983 was passed, right after, in the wake of the Civil Rights Act and the 14th Amendment. Okay? 83 was basically dormant for 90 years. People forgot about it. From 1871 to roughly 1961 to the 1960s. It really was, it was unclear as to exactly how 83 applied to the states. You know, what can be taken to a federal court, what has to be taken to a state court, and people pretty much ignored it. And we're well aware of the Jim Crow years in the South and the abuses and discrimination and hangings and all of that, lynchings, all of that took place with black free slaves and descendants of free slaves. In the 1960s, the Supreme Court became very, very active in resurrecting Section 1983 and applying it, making sure it was being applied to various of our nation. The Supreme Court justice in those years was a fellow by the name of Earl Warren, Warren, and that court in the 60s is frequently referred to as the Warren Court. And that court began to clarify and specify and articulate the fact that the Constitution, in accordance with 42 U.S.C. 1983, does apply to various groups. And for our class, for this purpose of this class, and you know this already, in 1961 in Monroe versus Pape, a case out of Chicago, Monroe versus Pape, Monroe versus Pape, case out of Chicago, the U.S. Supreme Court made it very clear that people who had been in police custody and felt that the police had violated their constitutional rights while they were in custody, those people can file a civil rights lawsuit in 83 action against the police in whose custody they were. See, before that time, before 61, people weren't sure, does this really apply to people in police custody? And the Supreme Court in Monroe versus Pape ruled in favor of the plaintiff and said absolutely. And then 3 years later, it clarified that prisoners also could file lawsuits against the people running the jail or prison in which they were incarcerated if they felt that their rights were being violated by those people. Cooper versus Pate, a case out of the Illinois prison system. Cooper versus Pate. And the Supreme Court ruled for the prisoner, the plaintiff, and said absolutely. People in institutions of incarceration, jails and prisons, if they feel that their rights have been or are now being violated by the people in charge of that institution, yes, absolutely they can file a Section 1983 lawsuit. So that's pretty much the history of it. The thing was resurrected by the Warren Court in the 1960s. And for purposes of this class, the two critical decisions, rulings of the Supreme Court, Monroe versus Pape, 1961, regarding law enforcement, versus Pate, 1964, regarding correctional institutions. Okay. I sure would like to have the opportunity to ask you if you have any questions, but I don't have that opportunity in this online setting. So if you have questions, please type them in, make sure I get them, or call me and I'll do the best I can to answer your questions, okay? Let's move on to section number 3 on your discussion outline. 4 essential elements of a 1983 lawsuit. For a lawsuit to be a legitimate 1983 lawsuit, 4 things have to be there. The first one, and these are listed on your discussion outline. The first one is a person. There has to be a person. There has to be a person involved. There has to be a person who is alleging that his rights were violated. There has to be a person involved, a plaintiff, somebody complaining. And it can be a flesh and blood person or conceivably a local government. Remember, you cannot sue the federal government or a state, but any unit of government below that is considered a person and can be filed on, can be named defendant in one of these lawsuits. Why that is, why you can sue counties and cities and hospital districts and school districts and so forth, and not a state or the federal government, I can't explain that to you. We need a legal scholar. And why those persons, I can't explain that to you either. I'm not able to. I don't think it's important for this class, but it's an interesting question. So, obviously you can file a lawsuit against a person, a flesh and blood person, if that person you think has violated your rights. A government can also be filed on. If a government has policies and procedures, customs or practices that violate people's constitutional rights, the government can be named as a defendant. And we talked about vicarious liability too. That comes into play here too. You can be held liable for the actions of another. You can be held liable for the actions of another. So if you run an agency, if you're the sheriff, and one of your deputies, like Deputy Pruitt, is named in a lawsuit regarding her handcuffing of Denicia Perry's client, if you're the sheriff, you can't say, hey, I wasn't there, I know nothing about this. Nuh-uh. You are responsible vicariously for the behavior of everybody that works for you, including Deputy Pruitt. So you can be held vicariously liable. And I think sometimes governments also can be held vicariously liable. If a government or the sheriff, for example, is responsible for training and supervising Deputy Pruitt, then they can be named as defendants if, in fact, she was not trained properly or supervised properly in the handcuffing process. So vicarious liability comes into play here as well. B, the second of the four essential elements, is that it says acting under color of law. So the person involved, we already talked about the person, has to have been acting under color of law. What that means is they have to have been acting as an on-duty employee of the government. Let me give you an example. If an off-duty correctional officer punches a parolee outside of a bar, he's not acting under color of law. He's just a citizen. He happens to be a correctional officer, but at that moment, he was not on duty. And so this is not a Section 1983 lawsuit. This is not material for a 1983 lawsuit because you have a guy who's not acting under color of law. He was not an on-duty government employee. On the other hand, if you have a correction punches an inmate in prison or jail for failing to obey an order, to follow an order, that is grounds for a Section 1983 lawsuit, because now you have a correctional officer who was on duty, functioning, acting under color of law, on duty, and he punched. He did something he is not allowed to do. Probably would be considered cruel and unusual punishment. Probably an Eighth Amendment claim. So acting under color of law is important. The third thing is there has to be an actual violation of constitutional rights. There has to be an actual violation. It must be demonstrated that it must be clearly demonstrated that the allegation involves a violation of somebody's constitutional rights. Not just discomfort, not just disappointment, not just being offended, but somebody's rights have to have been violated. Examples, I mentioned, I think it did I in class when I was this took place in North Carolina, in Charlotte. We had Muslim inmates who wanted to have prayer rugs to kneel on when they prayed during their holy season of Ramadan. And we were concerned that some of these prayer rugs were quite ornate, and we saw fights and theft and so forth being caused by this. So we consulted with a Muslim imam and learned that it's not necessary to have a prayer rug. What is necessary is that your knees cannot, as I understand it, cannot touch the ground or the floor. There has to be something between your knees and the floor. And we suggested and he was fine with this, that inmates simply use a piece of clothing or a towel or a piece of bedding that they have. So we did not, there was no First Amendment claim here. We were not denying these inmates the opportunity to freely exercise their Muslim faith. We simply were denying prayer rugs, which are not essential. If they want to use a prayer rug, they can do that in the free world. The government cannot come into a mosque and say no prayer rugs. But we felt we had a reason in terms of safety and security of the institution to deny these rugs. So there were no grounds for a 1983 lawsuit there. On the other hand, if you deny or delay medical care, inmates have the right to medical care. And if you deny or delay that at the expense of the inmate's health and well-being, that's probably an Eighth Amendment claim right there, cruel and unusual punishment. If you read attorney mail in the institutions, if mail came in from an attorney, we could open it in front of the inmate. We could open it, inspect it for contraband, and give it to the inmate. We couldn't read it though. If we went ahead and read an attorney's mail or an inmate's mail, incoming mail from an attorney, that's probably a Sixth Amendment violation. There's probably grounds would be there for a Section 1983 lawsuit violating. Part of your right to legal counsel is confidentiality, that relationship between you and your attorney, and you could make a strong case that we had violated that by reading the mail, by reading the attorney mail, and so that's what we're talking about there. And the fourth thing, the fourth element there, it says causes. What that means is that whatever the defendant did or didn't do was the actual or proximate cause of the civil rights violation. Proximate means immediately preceding or immediately following. We mentioned this, I think, in Module 1. So whatever violation is being alleged, the named defendant has to have been the proximate cause of that violation. Okay, so those are the four essential elements of a 1983 lawsuit. Those four things have to be there it looks like they're there for a case to proceed in court. Regarding causes, just an example: if a correctional officer unknowingly places an inmate in the same courthouse holding cell with another inmate who hates him, maybe a rival gang member, and proceeds to beat the hell out of him. The correctional officer is not a cause of that, is not an approximate cause of that. He's not a cause of it at all because he didn't know. He didn't know. The inmate never communicated to the staff, please keep me away from this other inmate because he's going to hurt me. Didn't know. On the other hand, if the staff was aware of the animosity that existed between these two inmates, these two gangs, and placed them together knowing that, yeah, then they could be considered the cause of the harm that ensued. In this case, physical harm, probably cruel and unusual punishment again. Anyway, those are the four essential elements. And again, I'd like to be able to ask you if you have any questions, but I can't. Item number 4 in this outline, remedies. We've kicked this can down the road. We know this. Monetary damages and equitable relief. Monetary damages, compensatory damages, that means somebody's compensated for actual expenses. In our hypothetical example, if Attorney Perry's client has spent $50,000 in medical expenses, trying to correct the nerve damage in his wrists, the court, if he prevails, the court may well award him $50,000 to reimburse him for out-of-pocket money or for loaned money that he has already spent getting medical care to correct or rehabilitate damage caused by Deputy Pruitt. Punitive damages. This is compensation if there was evidence of some sort of malice, a malicious intent on her part, or sadism. If it could be shown, if perhaps there's a witness who heard Deputy Pruitt say something to the effect that, I hope your hands are blue by the time we get to the jail. You've given me enough problems, and I'm going to give you some problems. If there was that kind of malice, Deputy Pruitt or any police officer, when you make an arrest, you have a duty to look out for the health and well-being of the person that you're taking into custody. And if it could be shown that she purposely did this to harm him, or if there's an allegation of that, and back up the allegation, and if a jury is convinced that happened, the court may award punitive damages also to Denise Perry's client. Again, those are compensation for malicious intent. And nominal damages, we talked about that. I've never seen it in my life, but a court occasionally will on rare occasions will note that, yeah, your rights were violated, but it's not that big a deal. So we're not going to award you $500,000. We're going to give you $1. And that's our way of symbolically acknowledging to you that yes, your rights were violated, but it's not serious enough. The violation was not that serious. Was not serious enough to authorize some large damage award. Nominal damages. Equitable relief is typically relief ordered upon the defendant agency or institution, and typically is in the form of an injunction. Somebody's enjoined not to do something they've been doing. I mentioned to you that one of the very first cases I was involved in is when correctional officers in the jail down in Jacksonville were taking a large inmate out of his cell, trying to get him to the clinic in this jail. And again, to calm him down, to get him under control, they were applying something called the lateral vascular neck restraint. And as I explained in class, the purpose of this hold, it's kind of like a chokehold, is to put somebody out for about 20 seconds, long enough for you to get them under control, get them in a restraint chair, get handcuffs on them, get leg irons on them, and then they come to again. Well, they killed this guy. And his survivors were awarded monetary damages for sure. But the Jacksonville Sheriff's was also enjoined to stop using that hold, never use it again. So that's an example of equitable relief. They were enjoined simply not to do that anymore, in order imposed upon the defendant agency. Number 5, who pays monetary damages? Who's going to pay if the Necia Perry's client prevails in this lawsuit? Who's going to pay? And he's awarded damages. Let's say $50,000 in compensatory damages and maybe another $100,000 in punitive damages. Who's going to pay that $150,000? Not Pruitt, not Deputy Pruitt. Typically, it'll take place in one of 3 ways. Some government agencies have an insurance company. They insure themselves with an insurance company. There are insurance companies who provide this kind of insurance for government, law enforcement, and correctional agencies. So there may be an insurance company involved, and they would make the payment. And your premiums would probably go up also. The agency may be self-insured. The agency itself may appropriate, when they put their budget together, the annual or the biennial budget, a 2-year budget, they may simply appropriate money, allocate money for this kind of thing. They may be self-insured, so the sheriff's office may wind up paying $150,000 out of its budget. A very common thing in many states, I'm not sure about Texas, but in some other states I've worked in, there's a state insurance pool. I was involved in one in Virginia. The insurance pool was operated by the state's attorney general, the attorney general's office. And how it worked is that everybody who was part of the pool would contribute a certain amount of money each year to the pool. And then if one of the members of the pool was named in a lawsuit and lost and was assessed for monetary damages, the payment would be made by the pool. Washington State is another place where it was. We were part of an insurance pool there as well. When I was there, we never had to use it. In Virginia, we did. No, I'm sorry, in Virginia we didn't, because that lawsuit didn't involve monetary damages. It simply involved equitable relief imposed upon us. One of the issues, and I wish we could discuss this, one of the issues is punitive damages. Is it fair? Should an insurance company, an insurance pool, or an agency pay for damages as a result of, should they pay for damages as a result of malicious intent? Should they pay punitive damages? So ultimately, it's your money. The money allocated by an agency, a self-insured agency, the money paid in premiums to an insurance company, or the money paid into an insurance pool for the state, that's your money. That's taxpayer money. The government doesn't have its own money. It has your money. So should you pay for punitive damages? To me, I wish we had a chance to talk about that. But to me, it's a really dicey issue, and I think, yes, in my opinion, punitive damages should be covered, because in situations where we're in dangerous, tense situations, police officers and correctional officers may resort to salty language, to aggressive conduct, which could be interpreted by a jury as malice. Might not be. I mean, officers are scared, and they are in danger of being hurt. It's not just the inmate or the arrestee. Officers also can get hurt or killed. That's a dicey issue, but I think in the vast majority of cases, punitive damages should be covered in one of these ways: insurance company, insurance pool, or by self-insurance. The government should take care of that. The provision of legal representation. I would just make this point. If I can find my notes here on that for a second. Keely Pruitt, Deputy Pruitt, is going to be represented by an attorney. And that happens in a variety of ways. The government itself may provide an attorney. If you work for the state, if you're, for example, a state trooper or an officer in a state prison, typically he'll be represented by the state's attorney general's office. Sometimes, if you work for the county like Deputy Pruitt does, you'll probably be represented by the county attorney's office, Dusty Gallivan, or somebody on his staff. If the appropriate legal agency, the AG's office, the county attorney, the city attorney, if that office is overwhelmed or busy at the time, they may contract with a private law firm that they have confidence in, that has done this before and is particularly good with respect to certain kinds of cases: crowding, suicide in a jail or prison setting, handcuffing, like our situation here, our hypothetical situation with Deputy Pruitt. They may contract with a private law firm to handle the case. In my experience as an expert witness, most of the time I'm working with a private law firm who's been contracted to handle a case by the when I work with defendants, that has been contracted with to handle a particular case by the AG's office or the county attorney, somebody like that. In some large agencies, like the Los Angeles County Sheriff's Office, that agency has its own attorneys. They don't rely upon the county attorney. They have their own legal staff because the system is so large. A friend of mine, who he's retired now, but he ran the Hillsborough County, Florida jail system in Tampa, a large system, about 5,000 inmates. They had their own attorney as well, their own in-house attorney. And in those cases also, if that in-house attorney or the in-house attorney's office is really busy, is overwhelmed, they also may contract with a private law firm in some instances. So that's how Deputy Pruitt and all of the government defendants are going to be represented. They are going to be represented by an attorney. You need an attorney. You're not thrown out there to learn how to swim on your own. You're going to be represented. The assessment of attorneys' fees. Let me just say a couple things about that. In a 1983 lawsuit, in these lawsuits, the court is not required to award attorneys' fees. Most of the time they do it, but it's entirely up to the court. It's at the discretion of the court as to whether or not, when they order in the final court order, when they order monetary damages to be paid and perhaps some equitable relief, they don't have to award attorney's fees, but they usually do. And so most attorneys who represent plaintiffs, like Denise Perry, they will present like an invoice. This is what it cost me to handle this case, and the court may elect to award all of those fees or a portion of those fees, but that's the way that's handled. And for a plaintiff's attorney to be awarded, and this is always plaintiff's attorney, government, they're paid by the government. They don't get attorney's fees. This is part of their job. In a law firm that contracts with the county attorney or the attorney general's office or the city attorney to defend somebody like Deputy Pruitt, their fees are taken care of in that contract. So we're talking here about plaintiff's attorneys like Denise Perry. And again, the court does not have to award her anything, but usually the court will, if she gains at least some relief. If she loses the case, all bets are off, no attorney's fees. But if she prevails in court and manages to get some relief for her client in terms of monetary damages or perhaps equitable relief imposed upon the defendant agency or defendant institution, that has to be there as well. So if a plaintiff's attorney prevails in court, that has to happen first. Then the court may decide to award her attorney's fees. Doesn't have to, but might. Okay, so that's typically the way that is handled. And now let's go ahead and walk through one of these lawsuits and see what actually happens. And here I want you to be looking at the handout entitled "Mechanics of a Section 1983 Lawsuit." Here it is right here. At the top it says Chapter 4, Section 1983 Lawsuits, and right below that it says Mechanics of a Section 1983 Lawsuit. So you should have that in front of you. I'm going to walk right down that graphic display, and we'll talk about what happens at each one of those steps. There are no numbers affixed to each one of those steps in the mechanics graph here, drawing, but I'm going to tell you what to put numbers in each one of those. I'll tell you what the number should be. The very first thing that happens is that an incident occurs. A regulation or right is contested. Something happens. There's an arrest, there's a use of force, a vehicle pursuit, a suicide in the jail. Something happens. Something has to happen for one of these lawsuits to be filed. And the plaintiff contends that when this happened, this officer or these officers violated my constitutional rights. So put in number 1 where it says incident, occurrence, or regulation / right contested. Put a number 1 there. That's the very first thing that has to happen. If that doesn't happen, if there's nothing, then there will be no lawsuit. Then it says suit filed, summons or civil suit. Just suit filed. That's all you need to be aware of. Put a number 2 there. The plaintiff then files a 1983 lawsuit. Probably name, and the plaintiff has no right to an attorney. Attorneys get involved. Attorneys keep track of what's going on. And if they see a lawsuit that has some legs that looks like it might go someplace, a lot of times somebody like Denise Perry will volunteer her services, typically to an inmate or to somebody out in the free world who's contesting or claiming that rights were violated when he or she was in police custody. So let's assume that we're at some point here an attorney is going to get involved, and the plaintiff is probably going to name, with or without an attorney, all kinds of defendants. Typically, in these lawsuits, there may be a whole list of people. Ultimately, many of them will be dismissed as defendants. But for starters, a plaintiff, sometimes with the assistance of an attorney, will name all kinds of people. And what happens is each defendant is served with his lawsuit. And I remember this from my days out there in the system. And your attorney will meet with you, review the lawsuit, review all the pertinent documents, incident reports, policy and procedure, sections of your policy and procedure manual, and any other evidence, and we'll review the case. We'll review the lawsuit. So that's number two. Plaintiff files the lawsuit in a court, and each named defendant is served. I remember in the lawsuit that where I was the named defendant, the inmate who had an attorney at this point filed the lawsuit in federal court in Alexandria, Virginia. And one afternoon, when I was in my office, a couple of U.S. Marshals came in and served me with the lawsuit. They simply said, "Here's the lawsuit. This has been filed in federal court. Here's your copy of it." And then, of course, I immediately got with our attorney. We started discussing this and discussing how we might approach this, how we should approach it by way of defending ourselves. Number three, it says defendant's motion to dismiss. Here's where, even before this, if it gets to this point, the court has not exercised its sua sponte authority. Remember, sua sponte is the authority of a court to dismiss a lawsuit without ever hearing from either side. But when we get to this point, number three, typically what happens is the court will ask the defendant, "We'd like to hear your response to this lawsuit. We'd like to hear your response to this. What do you say in defense of yourself?" And what happens then, and what happened to us, is we got together and put together our defense, our response, and concluded it with a request to the court that it issue a motion, that it issue an order of summary judgment or dismissal. We asked the court to dismiss this. So that's number three, summary judgment. Remember, sua sponte, about 74% of these cases are simply dismissed by the court without asking the defendant for a response. And another 20% are dismissed after the court sees the government's response and is satisfied that it's a good response. So anyway, at number three here, this is where the defendant files its response and concludes it with a request that the court dismiss this thing, issue an order of summary judgment. And you can see the arrow off to the left there. If the motion is granted, there's no liability, everybody goes home, it's over. On the other hand, the arrow to the right, motion is denied. That's what happened with us. The federal court said, "No, we're not dismissing this thing. You are severely crowded, and the conditions of confinement for your inmates are affected by that crowding, severe crowding. This thing's going to go forward." So the next step then would be number four, discovery. And there are five. Let me talk about discovery. There are 5 tools of discovery. They're listed there, and discovery. And I want you to know this for your exam. I just want you to know it anyway, but certainly for your exam. Discovery is the process by which one party gains information held by the opposing party. In other words, the plaintiff and the defendant. In our case, of course, the plaintiff was a former inmate. By the time he filed the lawsuit, he was not with us anymore and had done time in the state prison system, and I think was on parole. But this is the process, the discovery process. In this process, the plaintiff finds out as much as he can about the defendant's case, and the defendant finds out as much as he can about the plaintiff's case. They explore each other's cases, and they do this in 5 ways. There are five tools of discovery, and you certainly need to know these. Number 1 are interrogatories. They're listed there. We're at number 4 now. Interrogatories are written questions that can, and I think they often can be used to harass the other party, but you have to answer them. All of this whole discovery process, you participated in it under oath. You have to answer things, provide things to the best of your ability. These interrogatories can be very, very time consuming. For example, in our case, we were asked, how do you respond to inmates' requests for medical care? How do you decide what inmates go where, or housed in what units? How do you do this? How do you do this? How do you explain this? It seemed to us to be harassment, but the other side may have been looking for something. And this is very, very time-consuming and staff-intensive. For this whole discovery process, as I recall back then, this is the late 80s, we had a main jail that was, we had a jail system, but our main jail where we took people in and housed inmates there as well. This is where our booking operation was, and this is really our headquarters. We were certified to hold 175 inmates, and we got up to 500 in that building. Obviously, fodder for a Section 1983 lawsuit. Anyway, as I recall, to take care of this discovery process, including the interrogatories, we literally had to take 5 officers off duty, I think a sergeant and 4 officers, and reassign them to this. And we took a conference room and turned it into like a war room. And of course, we had to cover the posts of these officers with other officers and pay them time and a half, overtime, for covering their posts. But interrogatories are written questions that you have to answer truthfully, completely under oath. Requests for production of documents. Request for a production, it says there. What that means is request for production of documents. The other side asked us for policy and procedure manuals, incident reports, rosters, schedules, photos. They might ask you for, we would like you to provide us with your on-duty rosters for each shift for the last 8 months. And you sit there and you think, why do you need to know that? Well, maybe they don't. Maybe they're just trying to tire us out, but maybe they're looking for something, and you have to provide it. I mean, we literally provided truckloads of documents to the attorneys for the plaintiffs in that case. Photographs, audio and video recordings, personnel files, investigation reports, internal investigation reports, autopsy reports, medical records, and the list goes on. Anything can be requested, and you have to provide it under oath. You cannot not provide something purposely. If you are not able to provide something, you need to be able to explain why you can't provide that. Request for admission is the third item there. I'm not familiar with this, but at the time, if a lawsuit, but what this means is if a lawsuit involves, let's say, 3 or 4 allegations, a defendant might be asked to admit to any of those allegations that it's not contesting. And if there are 5 separate allegations, 5 alleged acts of wrongdoing, 5 alleged violations of somebody's constitutional rights, and if you can admit to 2 or 3 of them, yeah, you're right, that reduces the amount of that reduces the workload if this thing goes to trial. It can save a lot of time and a lot of staff man hours if some of the issues can be settled without contesting them in court. Settling issues prior to trial, simplifying and shortening the trial if there's going to be one. Depositions, these are out of court. This is a deposition is testimony given out of court under oath, and it's transcribed. Typically, I've been involved in a lot of these. Typically, you will sit at a table. Your attorney will be to one side of you. A court reporter will be near you, probably on the other side of you, recording all this in whatever way they do. Court reporters to me are amazing. Every cough is recorded in their report. And elsewhere at the table is the attorney for the other side. In our case, it would be the plaintiff, asking you questions, deposing you, and you have to answer. You take an oath before you start the deposition process, and when it's all over with, usually several weeks later, you are given the court reporter's typewritten report or deposition, the transcription of your deposition, for you to proofread and make sure it's accurate, and that becomes part of the record. And if this thing goes to trial, the attorneys, and I've had this happen to me, the attorneys might say, well, in deposition back 2 months ago you said this, and now you're saying this. It doesn't seem to be consistent. Can you explain that? So depositions are very important, and they can be taken in a variety of ways. They can be taken in person. They can be taken by telephone. In this building, there's a room up on the 4th floor of the Mesa building, which is now, I think, an office or a storage place. It used to be a conference room, and I can recall one afternoon spending noon to 5 up there, 5 hours, being deposed by telephone by an attorney out in Seattle. I've been deposed at the Seed building, operated by the university out near the airport. An attorney actually came down from Wisconsin, and we were able to set a room up down there for a deposition. There are court reporters in both Midland and Odessa. One of the larger ones, it might still be called Permian Court Reporters. And I've been deposed in that office in Midland, personally, with an attorney right there, the opposing attorney right there, by telephone down there, and also by a video where they can see me and I can see them, and we operate like interactive television. So anyway, that's what a deposition is. And then the last thing is that examination of injuries. We are hearing about the injuries sustained by Denicia Perry's client, and they have entered a statement by his doctor about these injuries. We want our doctor to examine this gentleman too. So an examination of physical or mental injuries. You might have a psychologist involved here. So the defense in this discovery process has the opportunity to examine the physical and mental injuries claimed by the plaintiff. And typically it'll be a physician, maybe a psychiatrist, a psychologist, a professional, a medical professional like that, doing the examination. So that is discovery. That's number 4. Number 5, it says mediation or arbitration. Sometimes the court, in order to encourage people to get together, sometimes the court will assign a mediator or an arbitrator to conduct a meeting or several meetings where the parties get together and try to work things out. I've never done this. I've never been a part of it. There was one point a number of years ago where an issue came up about visitation in the Midland County Jail, and there was some talk about perhaps the federal judge asking me to mediate a meeting between the people complaining. I don't think there was ever a lawsuit between the people complaining and the sheriff's office. Never happened, but I know people who have functioned as mediators and arbiters. I think with mediation, the mediator simply facilitates discussion, doesn't make a recommendation to the judge at all. With an arbiter or an arbitrator, that person will facilitate discussion and then subsequently make a recommendation to the judge as to how he or she thinks the case ought to be resolved. That may or may not happen. I've never been involved in a case where there's been mediation or arbitration. Right below that, settlement or consent decree, no trial. Put in number 6 there. That often, in the cases that I'm familiar with, including the case where I was a named defendant in that crowding case in Virginia, we entered into a settlement, into a consent decree or a consent order. I explained that to you in class, I think. And there was no mediation or arbitration whatsoever. The judge simply said, if I were you all, I'd get together and try to work this out. 9 out of 10 criminal cases are resolved with a plea bargain. There is no trial. And in the civil arena, I don't know what the percentage is, but a lot of these are worked out with no trial. They're worked out in the form of a consent order or a consent decree. And what happens there is that the parties will get together, they will agree to certain things, and they will put this consent order on paper. It looks like the judge has issued an order, and there's a place for him to sign it. There'll be a proceeding in the courtroom. The judge will say to the defendants, do you agree with this? Plaintiffs, do you agree with this? Yep. Okay, I'll sign it. And that consent order assumes the same authority as a court order had there been a trial. When I was the named defendant in Virginia, we entered a consent order. We entered into a consent order, and we were under that order for 20 months. It was as if there had been a trial, except we were able to work out some things and probably come out of it looking better, suffering less damage than we would have had there been a trial, because there's no way we could have defended housing 500 people in a facility licensed to house 175. Anyway, that's what a consent order is. And then number 7, see where it says trial? If the parties cannot get together and negotiate some sort of consent order, then we go to trial. And remember, we said that about 4% of these cases are resolved with a consent order, and about 2 go to trial, about 2%. So not many go to trial. But if they do, it's at number 7 there. And a trial can, if you walked in to the federal courthouse in Midland, for example, and one of these things was going on, it looks very much like a criminal trial. Jury selection, presentation of evidence to a jury, first by the plaintiff and then by the defendant, closing arguments, jury instructions given to the jury by the judge. And the jury, one difference, of course, as you know, is that the standard of proof in a civil trial is not proof beyond a reasonable doubt. It's simply preponderance of the evidence. So a juror might, and I've explained this to you in class, I believe, a juror might think that I think that maybe Deputy Pruitt, performed her job as well as she could under difficult circumstances. But I also think that there's some merit to her case. And I think the county attorney's office did a good job of defending her. But I think Perry did a bit better job. So it's like 60-40. So I'm going to vote for the plaintiff, represented by Denicia Perry. So it's a preponderance of the evidence, not proof beyond a reasonable doubt. And of course, either party that loses can appeal this. In our area, the appeals go to the Fifth U.S. Circuit Court of Appeals in New Orleans. And a judge, if the jury comes in and presents its decision to the judge, it rarely happens, but in the federal system, a judge can issue a directed verdict. And usually a directed verdict. Please know that. So a judge might, typically it occurs when the jury rules in favor of the plaintiff. A judge may say, well, this is ridiculous. You didn't understand my instructions to you. When I gave you my jury instructions before you recessed to deliberate, I explained to you the legal principles involved here, but obviously you didn't understand them. The defendant should have won this case. So I'm going to reverse you. I'm going to issue a directed verdict in favor of the defendant. A judge can do that. Rarely do they do it because they respect the jurors and the role that jurors play in our legal system in this country. So rarely do they do that, but they can. They can also adjust the damages. If a jury says that we feel that Attorney Perry's client should be awarded $300,000, the judge may say, too excessive. I agree. I'm not going to issue a directed verdict reversing the jury's conclusion or decision in favor of the plaintiff. I'm not going to do that, but I am going to adjust this damage amount. No, not $300,000. It's going to be $50,000 because I think $300,000 is excessive. So that's what happens at trial, and then you can see if there's no liability, case is over. If there is liability, at number 8 there, put down next to liability. Next to trial, it should be number 7. Next to liability, number 8. And of course, that's where monetary damages are awarded or equitable relief is imposed upon the defendant agency, one or the other, or both. And then number 9, I've added step number 9 to your handout, vacation. This doesn't mean that everybody involved goes on vacation, although you might feel like it. But this means that the order is vacated. That in our case, after 20 months, we felt that we corrected everything that the court had ordered us to do. We got our population way down. We reinstalled, reinserted, reactivated all the programs that I had discontinued simply because we had too many inmates and it was dangerous to be moving that many inmates from place to place to participate in these various programs. So we reinstalled all those programs. We felt in the course of 20 months we had worked with the community, with law enforcement and the prosecutor, a team effort to reduce the population in the place. We had also added some additional beds. We had added one additional building, prefab building, where we could house up to 240 inmates, which relieved our main building quite a bit. So we felt we had addressed everything the court was concerned about, and we filed a motion asking the court to vacate the court order. We asked the court for an order of vacation. That's what that means. Doesn't mean that we all went on vacation, but we asked for an order of vacation, and the judge granted it. I still have it in my office, right behind me here. So after 20 months, we were no longer under that consent order. By the way, and this question was raised by a student in a previous semester, can a defendant who violates a court order be criminally punished? And the answer is yes. If you, for example, run a jail like I did, and you're under one of these consent orders and you violate it, you can go to jail. And by the same token, if there's a trial and the judge issues an order, not a consent order, but in that case, an order as a result of a trial, and you violate that order, you can be sent to jail. You can be criminally punished. You are in contempt of court, and that's a crime. Okay. That's it for this module. Again, I wish I could ask you if you have any questions, but I can't. So make sure if you do have questions, type them up and get them to me on Canvas. And also, you can call me and I'll be as responsive as I possibly can be. But that is a Section 1983 lawsuit. And that's in some amount of detail. And we will continue talking about these lawsuits, different aspects of them, in the remaining modules for the semester. Okay? So that was Module 2. And I will see you for Module 3. And I hope all of you stay safe and healthy. Thank you.